pleased to have with me today, to my immediate left, Vernon Char, and to his left, John Jubinsky. Now, Vernon, can you tell me what is your bar number and a little bit about how you have spent your career?
Okay. I think I have the lowest number for the active practitioners. I'm 148, and I think it started in 1959. Ju probably has more information on that, but we were numbered in 1959 when we achieved statehood. When I first came back from school, I went to the Attorney General's office, practiced there for a bit, left, and then came back to the Attorney General's office to start the first program on antitrust. That was about 1962, I think it is.
Okay. And John, what about you?
Well, I came from Pennsylvania. I came to Hawaii for the first time in 1958 between my second and third years of law school with a couple of guys who were in my class at the University of Chicago. So I worked that summer with the Stevenson and Ashford firm. I lived in Kahuku, and I commuted by bus in 1958, and my compensation was $1 an hour. I remember that very well. And in those days, there was a one-year residency requirement to take the bar. So while I was here, I established residency. Then I came back in 1959 and took the bar, went to work with the Ashford firm after I did my stint in the Army. And you'll see, we're going to show a picture of our swearing-in ceremony, and I'll show you where I am on that one.
Well, you know, that's a fascinating photo that you provided to us for today, so it'd be wonderful for the audience to see that. And I'm hoping that maybe you can identify most of the people in that photo for us.
Well, I'll let Vernon do most of it, but I can identify myself. There's one person there in an Army uniform, and that's me, because here's what happened. In 1959, the bar exam was given once a year, the first week in October. It was 5 days. It was from 8 to 12 on 5 separate days, all essay exams. And I finished the exam on a Friday, and on Monday morning, I was in Schofield Barracks in uniform in boot camp. And we got sworn in, and as I recall, Vernon, in November of 1959. I was in Kahuku in the bivouac, and they were shooting live stuff, and I was in this foxhole. And I called Leota Crone, who was then the clerk of the court, and said, Leota, you got to get me out of here. Tell the colonel I have to be there for swearing in. So that's why I'm there with my Army uniform on. She got me the hell out of Kahuku and that bivouac, and that's why I'm there now. Vernon is in that picture, and what are there, Vernon? I think there were 32 people sworn in in 1959.
Right. It was a record year, I remember, because I think 50% of the prospects passed the bar. Prior to that time, it had been as low as 25%. Some of the names that I recall seeing, because I can't see the picture now, Jim Funaki, Roy Nakamoto are both practicing. Yeah. Unfortunately, I would think probably half, if not more, of the people in that picture are not living anymore.
So can you just tell us, Vernon, which one is you in that picture?
Oh, I can't see that well to tell you.
I think that he's the fourth one from the left with his head sticking in there.
Yeah, if I'm the one with the head sticking, yeah, right.
That's him. That's
right.
him.
Well, you know, this is interesting to me. I want to ask you a question about that. Now, you were both sworn in 1959. You have number 148. John, you have number 253. But there's a lot of lawyers who have numbers that are lower. I mean, I'm higher than yours, but they were licensed before you. Now, how did that happen?
Here's what happened. When statehood happened, the bar decided to number the people, and they did it first by island. So I'm pretty sure of this, but not 100% sure. They started Oahu in 1960 at 101, and I think Oahu went to approximately 800. So there weren't 800 lawyers there, because the last one I could see is a little over 500 at the time of swearing of 1960 or 61, thereabouts. Then if you look at the Maui numbers, you'll see Crockett, for example. Wendell Crockett, I think, was 804, and he's the first one that was still alive. The only book I have is a 1976 book, so that's what I've been working on. And then they moved, again, alphabetically to the Big Island. So you had guys like the Case brothers and Cades, and those people were well before us, but they have higher numbers. So it was alphabetical by island is what happened.
Right. So the first numbers probably would have been Peter Aduja, Bellamona, Anderson, Martin Anderson,
Yeah.
Page Anderson. And even though they had passed the bar before we did, it was alphabetical from 1959. So statehood was a real pivotal year.
So if you had practiced law in 1958 or 1957, you did not have a bar number?
You would have a bar number in 1960. You didn't have one before then, though.
Yeah.
And you would have been in alphabetical order when they first came out with the number.
Right. I think
You would have been way down.
looking at the list, though, I think the oldest practicing lawyer with a 3-digit is probably Vernon Char. He's still active, and I think he passed the bar in 1950.
Okay.
Well, I'll give you an example. I was telling him, I had dinner last night with Frank Padgett. Frank is 91. Frank's bar number is higher than mine, but he's been here since, I think, 1945 or thereabouts. So that's the way it went. He was the victim of the alphabet.
Okay. So back in 1959, when both of you passed the bar, what was it like integrating into the practice of law? I mean, for today's graduates, they have a lot of competition, few jobs. Were things any different back then?
I think John's perception and my perception are very different. When I came back in 1959 from Harvard Law School, the firms were segregated. I think lawyers in general mirror society. We like to think we influence society as well, but there were, if you looked at the economy at that time, you had the big five, the big sugar factors, and the other large companies like Dillingham, the trust companies and the large banks. And they were administered to by 2 or 3 large law firms. Anderson, Wren & Jenks, which is now Goodsell, Smith, Waugh, Beebe and Cades, which is now the Cades office. They service the large establishment type businesses. They did not have any Asians in their as attorneys. No women. I don't think they had any women either. Come to think of it,
They did, a few.
And so when I came back, I made inquiry at one of the firms and was told that that they would love to have a Harvard lawyer, but they didn't think their clients would understand having to deal with an Asian. So I think most of the Asians went out either in small practices or into governmental practices. Of course, we were the beneficiaries in 1959 of all of the returning veterans who were then very prominent. But in those days, my recollection is that if you were Chinese, you went to Heen or Hiram Fong. If you were Japanese, you had your lawyering done by Kashiwa or Kobayashi or Hiroshi Sakai, Vernon Kamo, or Kamo and Morita. And so there was somewhat of a allocation, so to speak, there. But that broke apart very quickly, I think, as soon as we returned. I think very early on, as soon as we again hit statehood, there were more and more lawyers coming in from the mainland, and the firms were beginning to hire Asians fairly shortly after 1959.
John, can you tell us what it was like for you?
Well, I went into a small firm. At the time I joined the Stevens firm, There were only 4 lawyers there. But Albert Ogawa, who was a Japanese guy, he came out of Harvard. He and I both came in at the same time in 1960 or 61. I went into the service in 59, didn't get out actively until I did this 6 months and then 5.5 years of the National Guard. But by the time I got out of the Guard and was practicing in 61, they were already starting to basically integrate, if you will, the larger firms. The Chinese were coming in, the Japanese were coming in, there was some movement there. And the big driver, really, I think Vernon said it right, was the veterans that came back, went to law school under the GI Bill. They drove that whole political change that happened in Hawaii with statehood. They were the leaders of the Democratic Party. They moved the Big Five, basically, and neutralized the Big Five in many respects. And then following the bar, actually, I think the bar opened up racially earlier than some of the clubs did. For example, Pacific Club didn't open up until much later. Waialae always had a bunch of Chinese and Japanese. Oahu did not. So the clubs were opening up as well. So statehood caused a lot of changes, and they came rapidly, I think. Vernon went to the government. I remember it because Vernon was getting $550 a month, and I was ticked off because I was only making $500 a month. But it was Jack Mizuha.
Right.
Jack was a Japanese guy. He was Attorney General at the time, and he was the one that finally started getting some of those governmental lawyers into a higher pay scale. Yeah. I mean, going from $500 to $600 in those days was a big deal.
Yeah. But to add to that, when I went out into private practice a couple of years later, and it was a firm comprised mostly of Chinese. It was Judge Dick-Yen Wong's firm, and I think my starting salary was $350. So stepped back to get into private practice, but then I went back into government service for other reasons after that, and then came out again.
Well, but I understand by 1963, Vernon, that you became president of the junior bar?
Right. And that's the story of why we're here today, is the Wednesday group. We were meeting, and our group of lawyers were, I think, are pretty interesting, the Wednesday group. There were people from the mainland, Howleys, that had local affiliation. And I think Phil and I were the 2 Asians in the group.
Phil Ching.
Phil Ching. And we immediately got active in the Bar Association and did the junior bar, which is now called the Young Lawyer Section. And we would meet, well, the junior bar was interesting from the standpoint that we started the first bar convention. We started the bar newsletter, the bar journal. The socials were all run by the junior bar. And that was the start of the Wednesday group, because our Wednesday group basically ran the bar. I think myself, and then after that Dwight Rush, and after that
Charlie Key.
Hod Greeley became junior bar presidents. Right. And we did all of these bar activities, but we would meet Wednesdays to plan whatever we were going to plan, and that continued on for the Wednesday group.
Okay, you know what? We're going to talk about all of that group and who those members are as soon as we get through with this commercial.
Okay.
Okay, so we're back on the air right now. Now, Vernon, John, I want you to tell me a little bit how this Wednesday lunch group got together. But first, tell me who were the members of that group.
Okay.
Vernon, you have the list.
I have a list here, and I guess that I should use the list. Of the 8 of us that started, Philip Ching, George Dyer, Hod Greeley, Charlie Key, Dwight Rush, and Jack Smart, and then Jube and I. We were from some local, some from the mainland, Howleys and Asians, private practice. One was in business, one was with a bank, and the others were in private law firms, big and small firms.
It was dominated by Harvard lawyers, though.
That's right. We didn't discriminate. There were, of the 8 of us, 3 of us were from Harvard, and the others from all really pretty good schools, Bolt Hall and Chicago, Stanford,
and Bolt,
and Hastings, and Miami.
Yeah.
And what was the first year that this group got together?
June 15th, 1963 is a date that we fixed about a couple of years ago in order to have an anniversary, a 50th anniversary party. We fixed it.
It was somewhere in 63. We're not sure, but it's very close to the date we picked, which is June 15th.
Yeah, and it would be formed by, I was president of the junior bar at that time, so we were meeting during that point.
But the interesting thing were the rules were that we rotated the turns. Everybody took their turn on a Wednesday. The host picked the restaurant, and you had to pick a new restaurant every time. And we had, I've forgotten what the first thing is. We paid $50, I think it was.
No.
Or was it lower than that? I can't remember.
Initially, it was $20. The object, I think it was also known as cheap lunch.
Yeah.
So initially it was $20, and then it went up to $75, and it's currently $100.
It's currently $100. But you know, we've cheated a few times, but in 51 years, I don't think we've probably cheated and gone back to the same restaurant. Now, we've gone to the same geography, but it's a different restaurant. And Philip Ching has a rule that basically says that if it's a Chinese restaurant with a new chef or a new cook, it's a new restaurant. We accept that definition. So, but we've been pretty good. And I don't know, Vernon and I, as a side note, my secretary's been with me for 45 years. Vernon's been with him for like 46 or 7 years. They run the calendar. My secretary tells me, my turn to host, where I'm going to go, because she's on it.
So this is every Wednesday, 52 weeks out of the year?
Every Wednesday.
Every Wednesday.
And it has to be a different restaurant?
Yep.
And it can't be a chain restaurant. So notwithstanding Ed Chun, no McDonald's, none of the chain restaurants. So.
Well, we've been to lunch wagons, though, but we've been to fancy stuff and some dives, too. But yeah, but you know, it is twofold. It's pretty much we're all about the same age, but we are racially different. We are politically different. We are philosophically somewhat different, I think. But we have some pretty good dialogues going with respect to what's happening in the law, what's happening in society, politics, and so forth. So it's more than just let's come and have lunch. And we do invite guests from time to time. We've had, for example, Justice Scalia has joined us about 3 times. We had Justice Stevens joined us. These are just us and him, these guys. It's one, what I characterized to Stevens, I told him, you are now meeting with 7 irreverent lawyers. We don't really give a damn. We're going to hear it the way it is. But it's interesting. It really is. And I think that, and Vernon is the one that really was the driver behind this, but there was a great deal of community involvement, a great deal of bar involvement, a great deal of give back to the profession, frankly.
Yeah. Well, you know, this sounds like a very diverse group, and one of you, I think it was Vernon, gave us a drawing so that we could show to the audience today. Looks like a pencil sketch that was made, and what's the story behind that?
Okay, as each of us achieved 60 years of age, a cartoon or caricature picture was made up for each one of us. In my case, I'm the one that's running, and I guess it was because I had run a number of Honolulu marathons, and so the motif was running. But the pictures there are of all of the 1, 2, 3, 4, 5, 6, 7.
Looks like there's 9 of you.
Okay, I think Jeremy is there additionally, but there are 8 in the group. Maybe by that time Jeremy and maybe Ed, because I think Jack Smart had died by that
Jack
point.
Smart had died, I think, yeah.
So
We've had some replacements.
we've had
yeah.
2 joining us, so it would have been 7 of the original 8, plus Ed Chun and
Jeremy Harrison,
who was then Dean of the Law School, joined us. And then currently we have Jeff Grad as a member also. Because if you look at that, of the 8 of us, there are 5 have passed away.
Now, are there any subjects for that lunch that are taboo, or do you guys just talk about whatever you feel like talking about?
Well, we have an informal rule that says you only have 30 seconds to talk about your maladies.
Right. And
Otherwise, we'll all be talking about our aches and pains, so we put a time limit on that. Other than that, it's wide open.
right. And it is wide open because there's a taboo rule that was enforced for me, or enacted for me, and that is can't talk about golf, because I'm a non-golfer. And they say, well, let's break the rule again. So there isn't a Wednesday that goes by without somebody's golf score or something about golf. But we do shy away from all the aches and pains and that type of stuff.
Well, you know, we are here to talk about the law. So I wanted to ask you, you had mentioned earlier that you felt that there's a little bit of mirror of society. How have you, Vernon, noticed that the law has either changed or evolved, or has it stayed the same?
I think it's changed a tremendous amount. And again, going back personally, when I talked about the Big Five when I first came back, and the law firms that were basically tied to the large business interests. I returned to the Attorney General's office to start up the state antitrust program in the early 60s. And it is interesting to me that the antitrust laws have been applicable to Hawaii since 1890 with the Sherman Act. But it was never enforced until the state came on board in about 63, passed a state law which was identical and mirrored the federal law. And I was brought back on to start up the antitrust section. 2 suits I think are interesting. One, interlocking directorates. We discovered that on these trust companies, AmFac, banks, the large entities, that the same directors were on multiple boards. And we determined that there were 85 directorate positions being sat on by 45 people. And these were competing entities, supposedly. Our first lawsuit was therefore to terminate those interlocking directorates. And it was a suit that was brought in the Quinn administration when I was working with Shiro Kashiwa. But it was continued and enforced by the Burns administration when I was working for Kobayashi. So interlocking directorates was one thing. There was a second one that the federal government stepped in, and the Big Five owned, the big sugar factors owned Master Navigation Company. The federal government came in and enforced the law, and the Big Five split off, so only one company ended up owning that company, Matson, and that was A&B. And the final thing that I recall was we had a suit that was, we felt was a concentration and a restriction of trade where Bishop Estate had 16,000 acres of land that went from pretty much Aiea all the way leeward, planning something like 20,000 homes over 20 years. And it was an agreement that Bishop Estate would provide the land, AmFac would provide the bonding and the building supply, and Joe Powell would build all of those houses over the 20 years, 16,000 acres. We brought a lawsuit at the Attorney General's office, and that agreement was terminated, and it opened up the land to various other developers and building supply companies and the like. So it was, to me, something that I did as a lawyer to influence society, and I think that society kind of opened up the state. There were other various things like mainland companies coming in too, but that law was very instrumental in that.
What about you, John?
Well, I went into private practice, and you know, in those days we were general practitioners. There were only 5 lawyers in the firm. I did everything from litigation to adoptions. The bar then was basically a volunteer organization. We were all designated and appointed to provide criminal defense. That was before legal aid and the protectors. Also, the Bar Association then was, the disciplinary procedure was governed by what we call the old Rule 16 committee, and it was a voluntary committee. Now, my first real deep involvement with the bar was as we moved from a volunteer disciplinary system to basically a paid system. We moved from the Rule 16 committee to a disciplinary board appointed by the Supreme Court. There were Baird Kidwell, myself, Shoeki Okamura, Nikki Nicholson. We drafted the original rule. We modeled it after the ABA a little bit, changed it, but that then became a professional organization in the sense that it had dues, requirements, and we hired our first paid person. I think it was Dan Healy was our first administrator. So the bar, the disciplinary process moved from a purely voluntary process to basically a more structured process and a more a professional process, if you will. And then when I was the second chair, Shoeki Okamura was the first chairman. And when I succeeded him, the first thing I really pressed for was getting lay people on that board. And we got lay people on the board. And we had lay people who were both male and female. And my goal then was, and I don't know what the mix is now, but I had always wanted not less than 50 people on that board, lay people, and I could say even more so. And I think that changed a lot of the disciplinary needs. The next thing that really came along was and I don't know which came first, I think disciplinary came before, the integrated bar. The integrated bar was not totally received by everybody. There were a lot of people who were opposed to it. But it was finally, again, a move to be a more structured and professional bar.
We're back again. I'm Calvin Young. You're going to see us every Tuesday. Now, John, I wanted to follow up on what last thing that you were talking about. When did you first become a member of this Rule 16 committee?
I was 16, probably in mid-60s, I would say. Norman Chung was then the chairman of it, and I think the disciplinary board got formed somewhere in the 1970 or thereabouts, or maybe even a little earlier. So I stayed on the board for about 18 years. And again, we moved to a whole different mindset, if you will, of how discipline was dispensed. And it's certainly a more formal procedure. And it has evolved since then into a more transparent one than even it was then. But the idea of interjecting lay people into the disciplinary process, I felt was a very necessary thing to protect the bar's reputation, frankly.
Now, was that something that you had seen in other jurisdictions?
I wasn't aware of any jurisdiction that had lay people on their disciplinary boards, frankly.
So we were one of the first.
I think so, but I can't say that categorically. But I know that we started small. We started about 3 people, all very much engaged. I remember David Kuhn, who was then headmaster at Iolani, came on the board. Alan Wilcox, who was A&B, came on the board. Madeline Goodman, who was at the university, came on. So we tried to get people from a variety of areas of the community. And I think that was very good. Basically, the movement in the bar, I think, was the disciplinary change, the integration bar, and then came law school. And then the law school came later. Law school was not really supported by a lot of people. There was a lot of concern, and I think Vernon can express some of the concern he had and I had when they were establishing the law school.
So what are your recollections about that time, Vernon? That would be like the late 60s, early 70s. The law school started in 1973.
I believe so. There was a lot of controversy on the plus factor was that a lot of our local young men and women could not afford to go away for law school. So it enabled a whole group of people who would not otherwise go to law school to attend. Again, when you think back, I think we were in 1959 on statehood about 600 lawyers. And I understand we've now passed the threshold of 10,000, with something like 7,000 that are still alive. Not all practicing, but huge difference. The concern I think some of us had, on the other hand, was that a concern that it would become, that the bar would be taken over by the local law school graduates, and that we would become parochial and not get the benefit of thinking of other communities, people going to other law schools and the like. I guess that's still up in the air. I know in my firm we have a lot of UH alumni, law school alumni. We have some that are not, but I think the majority of lawyers in town now are probably UH Law School.
John, what are your memories of that?
I was concerned that the law school was going to be basically a breeding ground for inbreeding among the governmental lawyers. I felt that they were going to pressure to get hired, and they would end up getting hired by the various state agencies and government agencies, and I was concerned that there would be a heavy concentration of that. I have since totally changed my mind. I think the law school has turned out to be very successful. Personally, I only have one complaint, and that is that I am very disappointed that more of the professors at the law school have not undertaken their task of being more critical of some of the judicial decisions that have been rendered. I don't see them stepping up to the plate as much as I wish they would as academics. I mean, you got Randy Roth there, you had John Van Dyke, you got David Callies, but other than that, I don't, maybe you guys see him, but I don't see him. And I think there were a couple of decisions that they should have stepped up and said, hey, you guys, this is not good law. Yeah.
So
that's the only complaint I have.
So as law professors, you believe that they're in a position to comment?
I think they have a duty to do that. They have a duty to tell the public and the judges that, hey, this is not the law. This is not the way it was. This is you guys making it up as you're going along. And I don't think they've done a good job on that. Well, so they can hang me for it. I don't care. I don't go there anymore, so I'm safe.
Well, I wanted to ask you about that. You know, you told us that you had started out litigating and things, and so how has that changed over the years? Like, can you comment on civility or professionalism?
Well, I have several comments on this, and I'll try to be brief. But the civility was extremely strong when we were small, and of necessity, it got more diluted as the bar got bigger. Obviously, you didn't know everybody. When we were going down to the Monday calendar calls, we'd all be there. We'd settle our cases on Monday afternoon, waiting for our turn of our argument at district court. And it was a different world then, but it was a smaller world, so it was easier. The question I would put to people, I have an opinion on it, but I would like to hear your comments on it. I believe that the profession has moved from a profession to a business, and we're more a business now than we are a profession. And the question I say is, where was the tipping point, and what was the tipping point in that transformation? If indeed you still believe that we are more of a business now than we are a profession. I'll answer the question my way, and that is, I think it started with advertising. When the FTC basically put the pressure on the American Bar Association to permit and indeed mandate advertising, I think that was the beginning of the movement to more of a business than a profession. And then the insurance companies start putting a lot of pressure on the defense counsel to be accountable by the hour. And then we moved to an hourly billing practice that, again, I think was a a movement towards the model of the business side rather than the professional side.
Vernon, do you have any thoughts on that?
Yes, I do. I subscribe to what Jube has just stated. I think there are several other factors. One, the bar has gotten much larger, so the civility, the camaraderie does not exist as much anymore. The days when we were a junior bar, we had great fun having bar picnics for the whole bar, and everybody would come out, and it was just assumed that people would come out to the bar picnic, and it was just a lot of fun. Functions such as that. Right now, I guess it must be difficult to try to get a bar banquet and expect, you know, a large percentage of the bar coming out to that. So that is one thing. The other thing is, I think we've lost some of the professionality. I think it's become very much a billing rate, an economic, it's a dollar and cents, so that I think the lawyers are much more mechanical, and thoughts of when we go back to our opening law school days, talking about, you know, your duty to the client, your duty to the profession, your duty to society, that whatever you did had to be in accord with all of those things. I don't think that there may be some people mouthing that. I don't see a demonstration of that much anymore, and I think that's sad. I think there's a lack of professionalism. But I want to put in a commercial for the Wednesday group. I think our group of 8, and expanded to a little more, we've had, besides the junior bar, we've had 1, 2, 3, 4 of us have been on the state bar president, like yourself. For the disciplinary board, I think not only was Jubinsky, but Ed Chun, and Dwight Russ was chair of that. Then going on to the ABA, Hod and I both were very active in the American Bar, both being on the Board of Governors. Charlie Key was active with the Bar, Council of Bar Presidents. Dwight was active with the Bar Presidents. So I think there was a lot more that we gave, and we don't see it as much anymore, giving back to the profession, the organized bar. And then finally, I think many of us, in our group especially, have gone out to do public service and acting on boards and commissions, university functions, and Jube has been very active with the Priory. I think our group probably is atypical at this point, that you don't see a group of 8 people having lunch, let alone not having lunch, but, you know, going out and getting involved in a lot of these legal and community events anymore.
Again, I think it's because of the pressure on billable hours, but I really am just so disappointed to see the decline of mentorship. I don't think there's the same kind of mentoring goes on for the young lawyers. I think they're forced to go out and swim before they're ready to swim, and primarily because of economics, frankly. And I don't know how you solve that problem, but I do think that they come out and they don't become as well trained as they otherwise could be if they had a good time spent with some people who would mentor what their activities were. Now litigation is so expensive, it's very difficult to get involved in serious litigation. And you know, I walk through the courthouses now every now and then. There's not much activity going on in those courtrooms anymore, except in criminal and family. The rest of them are all settling out, and they're probably moving to mediation and arbitration as well.
Well, John, right now you're involved with title guarantee, is that right?
Yeah, I'm still general counsel, still active, practicing full-time, yeah.
And what type of changes or anything have you seen in that area of law over the years?
Well, the landscape on real property law has changed dramatically. It started with statehood. Prior to statehood, the economic drivers of development were the insurance companies. Mass Mutual, Northwest Life, New York Life, they were the ones. When we became a state, the banks, the Eastern banks particularly, then opened up to providing financing. So that vehicle, plus the political vehicle that happened with the lawyers coming back from the service, and the jet, is really what changed that part of Hawaii, I think. Those three factors, I think, were the big drivers behind the economical changes. Then we had the wave of the Japanese investors coming in. Now we have the Chinese people coming in, and they have been fueling it. Real property's gotten very complicated. It's gotten much more difficult. During Vernon's time and my time, some of the legislation started with the enactment of the land use laws, the condominium laws. All of those things came in the probably late mid-60s or thereabouts, and that changed the landscape there. But real property's got more complex.
Okay, Vernon, any thoughts?
Just a general view. I think, you know, we often say to ourselves, we're glad we practice when we practice law, because we could practice and be a general counsel, like a family doctor, to a client. In this day of specialization and billable hours and teams of people coming in, there's so much specialization that I think many of the attorneys don't really know their clients. They're not, you know, they don't go to their client's son's birthday or the trustee of their kids, or worry about their estate plan, or handle their litigation or their business matters. It's a rare attorney that does that anymore. In a way, that's sad, because I think we as lawyers, when we get out of this general practice of general counseling for a client, lose that client relationship. And I don't know if there's any solution to that, but you know, it's there.
What about in your own practices for the two of you? You're saying that maybe young lawyers today aren't mentored enough. Do you have any suggestions? I know you said you didn't have an answer, but do you have any suggestions, thinking back on how it was for you, how we might bring that forward?
Again, the economics are so difficult to hurdle. I don't know how you can do it, except you just got to put longer time in, and that's difficult because nowadays there's a lifestyle differential too, and there's a lot of single parent lawyers out there. It's very difficult, I think. So all I can say is you know, I just spend a lot of time with them. I just, you know, the days start early and they end late, and that's what I think you got to do.
Yeah.
And you don't bill for it.
I think you're doing some good things. I noticed you have a leadership conference and trying to get young people involved in the process. I think that's a good thing. I think there's a lot more bench and bar kinds of activities. I think anything that can create more relationships are good things. I don't know whether the other model is going into the sections and having that be the paramount rather than the general bar, and whether you can begin building some mentorships there. It's a much more difficult problem because we have so many lawyers. But you know, I applaud some of the efforts that your bar is doing now, or our bar, but your leadership. So I applaud that.
Well, I want to thank you for your comments and thank the audience for joining us. It's been a wonderful conversation with Vernon and John, and I hope all of you tune in again as we continue this process for the next year.